So good afternoon, ladies and gentlemen. I'm very pleased and honored to be able to speak to you this afternoon. Unfortunately, I should be accompanied by my doctoral student, Szymon Skalski, who is very much into the tech issues in our team, but his flight got severely delayed by 8 hours this morning. While I was at 5 a.m. this morning awaiting my flight to Fiumicino, he wrote me that his flight will not take off this afternoon. So I'm pretty tired, but I'm here. He may be tired too, but he's not there. And he will listen. He will follow us online. Our topic has, I would say, a fairly general area, surface to it, a dimension to it, and then we move on to much more specific issues, namely from the general framework on AI automated decision making, we move into one specific sector, which is insurance, law and regulation, just general insurance, as an example of a sector that is fairly densely regulated, and provide some examples of how certain issues are being subject to regulation. I will, if you permit, Teresa, I will engage what you said in some specific examples, because there are many tort lawyers in this room, and two days ago I had a lecture in Kraków on the assumptions and basis for tort liability, and I made up one of my favorite examples, which will show up in a minute, namely one of my favorite heroes. I cry every time I saw this film, Baymax. So if I now run a Baymax around this room, he will come to each of you, ask you, can I check your blood work? How are you doing today? Can I measure your tension? You will smile, But imagine something goes wrong and Baymax punches each of you, So what basis of liability do we need to attach liability to someone, And what is my students were a bit perplexed. I told them fault liability does not really work here. Who shall we assume? Shall we attach fault to Baymax himself? That would presuppose Baymax is a legal entity, and I will in a minute I will go to a low-level common law court decision which grappled with the idea. But as the law stands now, wherever, I believe in any Western or non-Western jurisdiction, this will not be possible to attach liability to Baymax on the ground that he or she or there are a legal subject. So we would need to attach the liability to myself as the one who brought Baymax into the auditorium, or someone else behind me, perhaps my university, vicarious liability for employees, perhaps. Or we could go back to the software developer or the manufacturer of Baymax. And then I was raising the question, so tell me, look, I may be let's say, some small level company who has developed Baymax, and I claim I consulted 10 Silicon Valley engineers. All of them said, this is state-of-the-art appliance, you should go on. Test it perhaps in a small room, how many people he will punch, and then go to your students. Well, it should go. But then the bad thing happens, he punches everyone in the room, 30 people are badly injured, and we have to attach liability to somebody. How would we go about that? We would probably grapple with the idea of attaching the liability to several people, joint and several liability, the one who has used the software running Baymax, so the university, myself, whatever. Then we would, of course, go back to the company who has produced, manufactured, licensed Baymax. So that's how the law would probably operate in most civil and common law jurisdictions. I recently reviewed a magnificent book on comparative tort law by professors Busani, Sebok, and dear Marta Infantino, who is in that room, and I think they would agree with this determination. Now, recently, this is still a low-level court decision, but it brings us beautifully into the topic that we are talking about. Namely, I don't have it on slide because it will probably be reviewed, maybe remanded. Moffat versus Air Canada. I don't know if you heard of it. So the airline Air Canada has been, by a low-level court, found liable for the actions of its chatbot. And I read a short excerpt from the judgment. Air Canada suggests the chatbot is a separate legal entity that is responsible for its own actions. This is a remarkable submission. While a chatbot has an interactive component, it is still just a part of an Air Canada's website. It should be obvious to Air Canada that it is responsible for all the information on its website. So the facts were as that the family members had to reschedule a flight following some death in the family, and chatbot misinformed them on some preferential tariffs. In the end, they were awarded damages amounting to what they overpaid. Yeah? And as one law-tech professor suggested, what the Air Canada had to pay, several $1,000s, was a small price to pay to be alerted that the chatbot was hallucinating badly. Yeah? So, but there will be probably further development on that. Perhaps it may be one of the leading cases on liability for chatbots and other automated systems. Yeah, but let me go on. So what is interesting about insurance, and what we want to have a closer look at in this presentation, namely one of the interesting issues, not only in insurance but in the financial services everywhere, is some emphasis on regulating advisors. And as we know, advisors tend to be very active or proactive. It is the essence of their activity to provide personal suggestions, recommendations, and this may, of course, incur liability. So I will skip that over because, oh, I'm sorry. Is this? Well, that's it. No. Sorry?
No, this is your third slide.
Okay, yeah. Yeah. Then, no, he went over. Okay. So, what we are interested in particular, is idea of applying the fiduciary standards to robo-advisors in the area of insurance. And the question to begin with, which I think where the case of Air Canada was helpful to show where the law stands. It is still very modestly developed, and we don't know much actually about how it operates. What is interesting about fiduciaries, that their level of say the standard of conduct goes much beyond, let's say, the general assumption of what a professional owes to a consumer. I will quote again from my common law, let's say, not honesty alone, but the punctilio of an honor the most sensitive is then the standard of behavior. That's Justice Cardozo, of course. Early 20th century Meinhardt versus Salmon decision, which is very often cited as the so the highest possible standard of conduct, acting in somebody's interest. And when your own interest collides with your client's interest, you have to disregard your own interest and prioritize the interest of your client. Yeah? We all know this legal framework has been in place at the European Union level since the MiFID first directive, so Markets in Financial Instruments Directive 2004. It has been accepted by both common law and civil law jurisdictions. Then it has been brought over to the insurance sector, where it has somehow shifted the paradigm from a more egalitarian relationship towards making an insurance distributor more a quasi-fiduciary, that disregarding his own interest, privileging the interest of the insurance buyer. Yeah? That's the theoretical way of describing it. But it's much easier than it seems in practice, because what we need to achieve is that we need to train those automated systems in a way that they actually mimic the behavior of a human fiduciary who will avoid all conflicts of interest, who will know I need to abstain from that transaction, and because otherwise I would be liable. The transaction could be invalidated. There would be liability because of conflict of interest. I'm taking kickbacks provisions and so on and so on. I have to abstain from recommending products that are suboptimal. I need to be clear about what is the basis for my advice. So that's much easier said than achieved. We know that the law in theory requires that. We know there is much case law and literature regarding human advisors. Yeah. But there is no case law so far, apart from this, let's say, low-level Canadian modest court judgment on how we can apply those sweeping principles to automated advisors, and whether the sector would actually accept that. When we are about to develop automated advisors, we need to put so many safeguards in place so that we come close to the standard of a human advisor. I don't know how much time do I have left. Almost there. Okay. As I said, I will go back to show you. So. There are several possibilities to think about that. So product oversight, so sandboxes, regulatory sandboxes, which is a buzzword in the last few years. So we could imagine that fintech companies run tests on how those advisors how those advisors function in practice. There could be adequate disclosures about who the clients are actually interacting with, whether they are served by fully automated system, and they could perhaps be given a choice, an option to opt out. I don't want to go. We could imagine a two boxes solution. One, I want to go on with the human-assisted advisor. I consent to be served only by an only automated run advisor. I would say the opinions are divided about whether disclosures are effective and fair or not. We know the big debate, and I think this could, in some people would probably not understand the content of that disclosure. Yeah, so we would have to have an asterisk, and in small print would explain what it actually means that a client is served by a fully automated system. Yeah. I guess I'm almost hallucinating. It's like but if we go down that route, like on what Ben Shahar writes and so on, and other guys writing about consumer protection ideas, policies, rationales, when we take that seriously, we have to go that route. But I think the law as it stands is still a few years away from such decisions. Yeah, I believe the case law will evolve very slowly, and will base its development on the well proven basis for liability, and it will be interesting. It will be interesting to see what we know and what is I would say what should be observed in the next few years. How the sector reacts to these duties, including the insurance sector, the insurance distributive directive, duty to act in the best interest of the client. Because if courts begin attaching liability to that general clause, which is fairly broad, when an automated advisor makes an error in recommending a suboptimal product, and a client could theoretically prove the database which was used included information about better products, it would be very interesting to see if courts could be persuaded to use that broad duty to act in the best interest of the client principle as a basis of liability. I mean, I presume this would have to be connected with national tort law, at least in the European Union. But I think that's a job to do in the next few years. Thank you very much, and also thanks to Szymon, who has been listening to us but couldn't be there. Yeah.